Thank you, Dallas. All right. Good evening, ladies and gentlemen. Welcome to this September 8th Planning and Zoning meeting. We appreciate you continuing to Zoom into these meetings and joining us virtually as we work through this time in our history. I'd like to begin by calling an approval of the agenda as it was published.
Motion to approve.
I have a motion from Chair Baker, a second from Naeem. Are there any comments, questions about the agenda as it was published from the dais? Okay, then Dallas or Brian, whoever's in charge, take us to, ladies and gentlemen, we have called the Planning and Zoning meeting to order. We are down one board member. Ms. Linda Woodcock is not able to attend with us tonight. We have a motion probably seconded on the floor to approve the agenda as it was published. If you want to call in and make a comment on the agenda, that's the item in front of us now. All you need to do to be able to do that is dial the phone number that's in front of you. Once we have you in the meeting, at the bottom of your screen, you'll see a little hand symbol. Click that hand symbol. That will let us know that you'd like to make a comment or you have a question about the agenda. And we'll make sure that you have the opportunity to address the board. Dallas, are you watching the public or is that Janine tonight?
I'm watching.
Brian, do we have anyone with their hand raised?
No, sir.
No, Mr. Mayor.
Okay. If you'll take us back to the board members. And again, we have about a 30-second delay between our live feed and the YouTube feed. So we're making sure we give plenty of time for folks to be able to call in and address you. But we have none at this time. So we'll go ahead and do a roll call vote. We'll start with Chair Baker.
Aye.
Member Johnson.
Aye.
Naeem.
Aye.
Bill.
Aye.
And just before I say motion passes unanimously, remind me, we don't have the historical board tonight. Who's on? Is Member Boyer a member of the P&Z? No. So he's just in as part of the public, or he's on the agenda tonight, but it's not, it says Member Boyer, but he's not a member. Just make sure I have that right. Motion passes unanimously. All right, that will take us to the Pledge of Allegiance. Brian, did you get us a great speaker to lead us in that pledge, you know, like John Wayne or somebody like that, or am I doing it tonight?
I'm afraid I failed you there, Mr. Mayor. I don't
I'll
have
do my best John Wayne voice. All right, if you would stand with me for the saying of the pledge. I pledge allegiance to the flag
To the flag
of
of the United States of America,
and to the republic where
for
it
which it stands,
one nation,
nation,
under
under
God,
God, indivisible,
with
with
liberty.
liberty and justice for all.
Okay. Next up on the agenda is approval of the August 3rd, 2020 minutes. Give you a chance to look over those minutes and then I'll entertain a motion as soon as the board is ready.
Motion to approve the minutes.
I have a motion from Chair Baker.
Second.
I have a second from Member Johnson. Any comments on the minutes? Any corrections, scrivener's errors, anybody found? Okay. Seeing no further comments from the board, Brian, would you please put our phone number back up?
Dallas, can you hit that? I don't have that slide.
Dallas, could you? There we go. Okay, ladies and gentlemen, we're at the beginning of the P&Z meeting. We have a motion properly second on the floor to approve the August 3rd minutes. If you wish to address the board on the August 3rd minutes, you may do so at this time. All you need to do is dial the phone number that's on the screen in front of you. Once we have you into the meeting, at the bottom of your screen, you'll see a little hand symbol. Click that hand symbol. That'll let us know that you'd like to make a comment to the board, and we'll make sure you have the opportunity to do so. Brian, does anyone have their hand raised?
No, Mr. Mayor.
So slowly bring us back to the board members. We'll do a roll call vote. Chair Baker,
Aye.
Gavin,
Aye.
Bill,
Aye.
Naeem.
Aye.
Motion passed unanimously, and that takes us to announcements. Do the board members have any announcements? Okay, one more time, Dallas, put the, do we want to do public comment here or just wait till the end? Do we have any members of the public in the waiting room, Brian?
No, Mr. Mayor.
Okay, well, let's move on and we'll make
Oh,
sure.
wait, I'm sorry. There's someone did just raise their hand.
Okay, wonderful. Well, we are at announcements. So if you have anything you'd like to talk to the Planning and Zoning Board about, now is a great time to do it. Simply dial the phone number that's on the screen. Once we get you into the meeting, you'll see a little hand symbol at the bottom of the screen. Click that symbol and we'll know that you have a question or comment you'd like to address to the board, and we'll make sure you have the opportunity to do so. Brian, would you please say the name of the person with their hand raised?
Ms. Susan Buzzard, one
Okay.
of the tonight's applicants.
All right. Welcome, Ms. Bussert. Did you have a comment or an announcement that you wanted to make here at the beginning, or did you just want to let us know that you're here and test out your ability to speak?
No, this is Mr. Broussard. I apologize. This is my first time doing this, so I wasn't sure. Make sure that it was made known that I was signed in. So
No problem. We're glad that you checked and we've got you loud and clear on our end.
thank you.
Okay, we have no old business, so that takes us to new business, which first item, number 2, a petition to allow the rear setback of lot 28 in Countryway of Newberry Phase 1 to be 3 feet 2 inches instead of 10 feet from the property line. This is a quasi judicial hearing, so we will move through the quasi judicial procedures. I'm going to begin by asking the attorney to read the resolution into the record for us. Scott or Rich, are you ready to do that?
Yes, Mr. Mayor, thank you. Resolution number 2020-42, a resolution of the City Commission serving as the Board of Adjustment of the City of Newberry, Florida for approval of a variance petition as authorized under Section 3.2.5 of the City of Newberry Land Development Regulations, providing for the back of an existing shed to extend into the minimum rear yard setback area as provided for in Section 4.2.4 on certain lands within the corporate limits of the City of Newberry, Florida, repealing all resolutions in conflict and providing an effective date. And here the appropriate motion would be to make a recommendation to the City Commission serving as the Board of Adjustments to pass resolution number 2020-42 as read by title only.
Thank you, Rich. At this point, I want to explain the rules for quasi judicial proceeding. When this board sits in quasi judicial, they move from a legislative body to a judicial body. So we have to abide by rules, especially rules concerning testimony. And primarily, this board can only consider substantial and confident evidence. That evidence must be met when this board makes a decision. And it is guided by the following quote: all public testimony will be taken under oath. Everyone testifying will be subject to cross-examination. All documents and exhibits shall be entered into evidence. The giving of opinion testimony is limited to experts, and closing arguments will be limited to the evidence of record. I'm going to ask if there's been any ex parte communication from the board members. Before I do that, I want to remind the board, especially Brian, who's watching our waiting room, that by our procedures, I'm going to go through quasi judicial one time, all the procedures and policies. If nobody new enters the waiting room, then I'm not going to go through this for the following quasi judicial proceedings tonight. We're just going to move right on through them. Okay, so Brian, I'm going to depend on you to let me know someone new has entered. We need to explain what's going on. With that, if any board member, and we'll do ex parte for each quasi judicial independently. So if you've had any communication on resolution 2020-42 that you need to disclose, let's do so now and start with Madam Baker, Chair Baker. That was a no.
I have none.
Bill,
No here.
Gavin,
No.
Naeem.
No.
All right, thank you. At this point, I'm going to ask Janine if she would swear in. Janine, do you want to swear in, or do you want me to ask the attorney to swear in? I'll ask the attorneys to swear in. Swearing in on a Zoom meeting is always a little awkward. So if you could click the little symbol at the bottom of your screen, the little hand symbol that lets us know that you need to speak or that you may need to speak. And again, we'll do swearing in on each individual quasi-judicial item independently. So if you just think you might want to speak on Resolution 2020, click that little hand symbol to let us know that you want to speak. And Rich or Scott, could you start with Wendy as a practice?
Absolutely, Mr. Mayor. Ms. Wendy, could you please raise your right hand? Do you hereby solemnly swear to tell the whole truth and nothing but the truth?
I do.
You are duly sworn. Do we have
Brian, do you have anybody else with their hand raised? Brian's has hand up.
Brian, do you hereby solemnly swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Janine?
Ms. Janine, do you hereby solemnly swear to tell the whole truth and nothing but the truth? You're duly sworn. You're on mute, but I saw the head nod.
Brian, do we have anybody else with their hand raised? Any members of the public?
I'm afraid I'm not as quite proficient at this as Dallas is, but I know that I had seen Ms. Michelle Jones had her hand up a little while ago, and she's the applicant on this one. But oh, wait a minute, I'm sorry. Attendees, I found her. Yes, there you go. That's
Ms. Jones?
Hello?
We're at the point in our quasi judicial where we need to swear in anyone who may need to give testimony. Are you prepared to swear in that you will
Yes.
tell the truth and nothing but the truth? If so, our attorney will guide you through it.
Yes, I am.
Okay, could you please just state your name
Michelle Jones.
and please raise your right hand?
It is.
And do you hereby solemnly swear to tell the whole truth and nothing but the truth?
I do.
You're duly sworn.
Thank you.
Okay, anyone else with their hand raised? We can swear you in later if we miss you. It's just helpful to get them all out of the way at one time. So seeing no one else with their hand up, then we will move on.
There's another hand up.
Ms. Buster.
For the next hearing.
That's the next hearing? Okay, so Mr. Bassard, if you want to speak to the next hearing, we'll swear you in for that one. We do ex parte and swearing in per agenda item.
Understood. Again, my apologies. My first time on this format, so I apologize.
No worries. Okay, I'm going to go through our order of presentation. We begin quasi judicials by allowing staff to give us a short overview, and then the applicant has the opportunity to make a presentation with no time limit. And then we'll get a staff report and their recommendation, also with no time limit. I've not been contacted by anybody wishing to claim a third-party intervener status, so that's going to take us to public comment. Anybody from the public will have 3 minutes to address the board on this item. And then the applicant may have the opportunity to cross-examine, and staff will have the opportunity to cross-examine. Then we'll move to the members of the decision-making body who, through the chair, may ask questions of the staff, the applicant, or any of the participants. Final arguments will then be made by the applicant and then the staff related solely to the evidence and testimony presented at the hearing and introduced into the record. Then the city attorney will advise the decision-making body as to the applicable law and the factual findings that must be made to approve or deny the application. Finally, the board will deliberate the application, and after deliberations, a vote will be taken to approve with conditions, continue, or deny the application. That is the set of procedures we're going to adhere to for all 3 of our quasi-judicial hearings tonight. And with that, I'd like to ask staff to give us the overview. Wendy, is that going to be you?
Yes, sir, it is.
All right, you have the floor.
Okay, we're going to get into our presentation. Okay. So our first slide just gives you the introductory thing. Let me close out these panel members so I can see my whole screen. I don't know how. All right, the next slide shows you the that this is an application whereas a variance to reduce the minimum rear yard setback. The first slide shows you the location of the property out on lot 28. And this is in the Country of Newberry Phase 1 subdivision, which is part of the Newberry Town Center Plan Development. The application is a request by Michelle and David Jones, who are the owners of the property, and they've requested to reduce the rear yard setback from a minimum of 10 feet to 3.3 feet 2 inches, on the north side of their lot. And that lot backs up to the common area for the property, and it's for that subdivision. And the purpose of the request is to allow the back of an existing temporary accessory shed structure, and that would extend 6 feet 8 inches into the recorded rear yard setback. But it's noted that the property is, there's a different kind of setback when you have accessory temporary structures, and that is that minimum of 5 feet to the rear yard setback. And accessory structures are allowed in your rear setback. And so this request would be encroaching into the 5-foot rear yard setback, since it will be 3 feet 2 inches from the property line. This is the set of the regulations, part 4.2.4, section 3, that addresses the temporary accessory structures. In this case, this is a unit that's mounted on blocks. It's considered temporary. It's not on a foundation. And the current placement, as I just described, is 3 feet 2 inches from the property line. And that concludes our introduction.
Okay, thank you, Wendy. Does the applicant wish to make a presentation? Wendy, do we have the applicant? Ms. Jones, is she here?
Yes, I'm here. Thank you.
Do you wish to make a presentation to the board?
Well, I don't have a presentation. I just would like to speak on it, if that's okay.
That's perfectly fine.
Okay. We have the shed. The shed's been there for about 3 years. And when we placed it, we had bought extended property there. Trip Lancaster, Norfleet sold us the extended property. So we bought the property and did not realize that it had to be 5 feet. It sounds like it may be placed within 5 feet. So we were thinking of the wording that it could be placed within that 5 feet. But the shed's been there for over 3 years, and we did purchase additional property to put the shed in. We didn't realize that it can't be within that 5 feet. It's only a foot and couple inches over into the 5-foot easement. I don't know if you can tell from the picture there or not, but you can see the dotted line where we bought additional property. And then
Ms. Jones, are you moving the cursor over what you want us to look at, or is that Wendy moving the cursor?
I'm
that's
doing
Wendy.
that.
Thank you.
Trying to-
But yeah, she's pointing to the right place. The dotted line there was what the original property was. And then we purchased additional property from Trip, and then did not realize, we thought we could be within the 5 feet. And now find out that we can't. And we're just trying, we already have a variance for the pool. So we're just trying to extend that variance along the back here of this new property.
Okay. Is that the extent of the comment you'd like to make? You'll have plenty of opportunities later in the proceeding to comment again. I just want to make sure we're not cutting you off before.
Yes, that's it. Thank you.
Okay, thank you, Ms. Jones. Okay, Wendy, you want to finish your staff report and give us staff's recommendation?
Yes, sir. So this, as Ms. Jones described, you can see the location of the shed, and you could see the location of the shed. Here it is, and that it's extending into the 5-foot setback. So it's got 3.3 feet 2 inches from the rear property line. So the regulations for the Board of Adjustment when they're making decisions and as when you're considering your recommendation to the Board of Adjustment, it's based on looking at the application and particular conditions for that property and why the situation is before you, what caused it, and if there's any unnecessary undue hardship as a result of not granting such a thing. The authority of the Board of Adjustment is to grant these variances to particular situations that are cause an undue hardship based on the regulations as they are in the code now. You're not able to grant a variance to something that is a specific requirement or specifically laid out in the code, except for those items that are specified as being able to grant variance to. In particular, in the conditions as here in this section of 12.4.1 regarding the variances to zoning regulations, it describes what kinds of conditions and what kinds of conformity to the regulations are required. Under no circumstances, as I was saying, shall you grant any kind of variance to specific uses or particular requirements that are specifically laid out in your land development regulations. It's based on a hardship, and it's the minimum possible variance that's granted for the ones that are being approved, and specifically that the granting of the variance will not be contrary to the public interest. And then, of course, it does provide for, if it were to be denied, that there's a 12-month calendar month limitation on when an applicant can submit for another application for a variance, and it would have to be for a different type of variance if it's going to be under those 12 months. So staff's recommendation is for approval of the resolution for the variance, and that should read variance and not STUP. But this is for resolution 2020-42 for the variance. And the conditions that are recommended by staff are specifically to address this situation, and that the minimum rear yard setback on the north side of lot 28 would be reduced to 3 foot 2 inches from the back, such that the temporary accessory shed structure shall not encroach greater than the 6 foot 8 inches into the rear setback area as shown on the resolution's Exhibit A, and that Exhibit A is the drawing that you saw that the applicant had provided with the boundary survey showing where that shed is. And that number 2, that the variance would be granted for a temporary accessory shed only in this location as it exists now and doesn't permit a permanent structure. And if the shed were to be ever removed, the variance would become void and any new structure would have to meet the original building requirements. The applicant shall obtain an after-the-fact building permit within 90 days of approval of this variance. Number 5, that the applicant would have to obtain all necessary building permits as applicable. The recommended motion is to recommend to the Board of Adjustment approval of Resolution 2020-42, approving application B2002 with conditions as presented by staff.
Okay, thank you. Wendy, again, not been contacted by anybody wishing to claim third-party intervener status. That's going to move us to public comment. Brian, if you would put our phone number back up on the screen, please. Or is that Dallas that has the slide with the phone number?
There we go.
Okay, ladies and gentlemen, we are on our first item of new business. It's number 2 on the published agenda tonight. This is about a petition allowing a rear setback in a lot and country way to be 3 feet 2 inches instead of 10 feet from the property line. We've come to public comment for this. So if you have a comment that you'd like to make on resolution 2020-42 in support or against, All you need to do is dial the phone number that's on your screen. Once we have you into the meeting, you'll see a little hand symbol at the bottom of your screen. Simply click that symbol. That'll let us know that you'd like to address the board. And we'll make sure you have the opportunity to do so. Remember, we do have about a 30-second delay between our live feed and the folks watching on YouTube. So we want to make sure we give plenty of time for them to participate. If you like to, now is the time. Brian, do we have anyone with their hand raised?
No, Mr. Mayor, we do not.
All right, then we'll go back to the board. Ms. Jones, did you hear anything in the staff's reports that you would like to cross-examine? If you disagree with, you want to ask?
No, I didn't. Everything sounded great. The only thing I meant to point out a minute ago and I forgot is that our property doesn't back up to anybody else's property. There's kind of like an easement behind our house, and then it backs up to a burn. So there's no one behind us that this shed is, backing up to. And I just wanted to mention that earlier and I forgot.
Okay, it's a good point to make. All right. Staff, did you hear anything that Ms. Jones has said tonight that you'd like to cross-examine?
No, sir, just that the property does back up to that common area known as Tract A, so that is correct.
Okay, then we'll move to the board. Board members, do you have any questions for staff or Ms. Jones? Bill?
Yeah, I have a question.
Go ahead, Bill.
Can you hear me? Yeah.
Yep, that's
Yeah,
loud.
I have a question for Wendy or Brian. When we approved the LDRs, it said you can only be up to 5 feet with a temporary structure like this. What was the reasoning behind the 5 feet? Why did we set it at 5 feet rather than another number?
Can we get that? Mr. Mayor, or Mr. Chair, that was, the reasoning behind that was because that would guarantee a minimum of 10-foot separation for fire safety code. If you had 2 temporary structures, each 5 foot from the property line adjacent to each other, you would still at least maintain a 10-foot distancing, which is what the Florida Fire Code requires.
And so since there's no other lot behind them, then we've got plenty of room. We don't have to worry about not having 10 feet, right?
Yes, sir.
Okay, I'm fine with it.
Okay, thank you. Any other questions from the board members? Chair Baker?
Mr. Mayor, the question I have, Mrs. Jones indicated there had been a variance for the pool. Do we know under what conditions we approve planning and zoning approve the variance on the pool?
Brian, do you have that history, or Wendy?
I remember it a bit, and it was generally the only conditions were that it was allow the pool to extend into the setbacks. Again, based in large part because there were no and would never be any neighbors behind them because it faces the common area or backs up to the common area. And so normally some of the flat work, the concrete decking is allowed into the setbacks without variance, but the pool itself normally wouldn't be allowed into the setbacks without a variance. And so that for that reason, they obtained a variance.
That conclude your questions, Chair Baker? Gavin, were you reaching for the mic?
I was just going to ask the same question, that the variance for the pool was specifically written for the pool structure itself, not a variance to move the setback for the entire lot.
Okay. Any other questions from the board? Okay, hearing none, we're going to move to final arguments. Ms. Jones, you absolutely don't have to, but if there's anything you've heard or you want to summarize to make a final argument, now would be the time to do so.
No, I'm good. Thank you.
Okay, thank you, ma'am. Wendy, does staff feel the need to make a final argument?
No, sir.
Okay, thank you. Mr. Attorney, would you please advise the board as to applicable law and the factual findings?
Mr. Mayor, we are governed by the substantial and competent evidence standard, taking into consideration the report from staff, the testimony and evidence submitted by the applicant, and any and all other documentation and testimony that the board has heard tonight.
Okay, thank you. Okay, board, now we are into deliberations of the application. If there are no more deliberations, we'll entertain a motion to approve with conditions, continue or deny the application. The original staff recommendation in front of you already has some conditions in it. So if you want more conditions, now would be the time to deliberate on that. Or we'll entertain a motion. Bill?
Mr. Mayor, I move to go ahead and recommend this motion to the Board of Adjustment for approval.
We have a motion. Do I hear a second?
Second.
Okay, I have a motion from Bill, a second from Gavin. Are there any questions or comments on the motion on the floor from the board members?
I have a question, Mr. Mayor.
Chair Baker?
So this might be a question for the city attorney. We have a part of all these variance applications is a notice to applicants with criteria that must be met in order to grant a variance. And there are 2, 4, 6 of them. I assume they have to meet all because it's got an and in there at the bottom. Where do these come from? Do they come from our comprehensive or our procedural or?
They come from our land development regulations. They're spelled out there. And I think you might be referring to the factors in section 12.4.1.
So one of my concerns is that we have, so we have these conditions that we're supposed to meet in order to grant a variance. And while I sympathize with the applicant, I'm unsure how this meets several of these items that they should meet in order for the variance to be granted, even though it has been recommended that we approve it with conditions. I can understand the hardship in having to move a shed, and that it has been there for 3 years, but it doesn't seem that it meets that it seems like it was the actions of the applicant. It's not something that where we've granted some of these before. It's peculiar to the shape of the lot. So I have concerns about that.
Okay. Any other comments or questions about the motion on the floor? Hearing none from the board members. Brian or Dallas, whoever has our phone number, go ahead and put it on the screen. Okay, ladies and gentlemen, we've come to the end of item 2 on the published agenda. This is about a rear setback in Country Way. We have worked through our quasi judicial process, and we now have a motion properly seconded on the floor to approve the resolution 2020-42 with staff's recommended conditions. If you'd like to call in and make a comment, you have a question, concern, or offer support, now is the appropriate time to do so. Again, we're only on item 2, so this is only about the rear setback in Country Way. If you'd like to make a comment, dial the phone number that's on the screen. Once we get you into the meeting, at the bottom of your screen, you'll see a little hand symbol. Simply click that hand symbol. That'll let us know that you'd like to make a comment to the board, and we'll make sure you have the opportunity to do so. Brian, do we have anybody with their hand raised? At some point, you're going to have to let us actually read that meme. But anybody with their hand up?
No, sir.
Okay, come back to the board. So the motion is for approval with staff's recommended conditions. We'll do a roll call vote. Chair-
Morlo, I do have a question. Is anyone, staff or the attorneys, able to address Chair Baker's concern? She kind of left that comment open-ended, but there doesn't seem to be a resolution to her concern.
Okay.
Sure, I can attempt to
Go
answer
ahead,
the
Scott.
question that was raised, if you'd like. This is Scott. The classic scenario for a variance is that it cannot be a self-imposed hardship. However, if the lot is a peculiarly shaped lot, which it appeared to me, and based on the map that was presented by staff this evening, that we have a pie-shaped lot, which typically you have very different setbacks when you have such a lot. In other words, we have a very narrow opening in front and narrow opening on the sides, and it is a very narrow in the back. So it would appear that that based upon a lot, and this gets to the discretion of the board, which frequently these types of variances are granted. And in addition to that, it's my understanding our staff sends out notices to the neighbors so that they can opine as to whether or not they have a problem with the variance, that this sort of thing is a fairly frequent occurrence in this area.
Okay, Member Johnson, does that, you've heard the concern and you've heard.
I appreciate that.
You're muted. Were you good, Gavin?
Yes, thank you.
Chair Baker, did you want to offer a further concern or?
No, but I will point out that included in our packet is an email from one of the neighbors who is notified with concerns as well. But that addresses my concerns.
Okay. Okay, any final thoughts before we call for a vote from any board member? Naeem?
So my question is this, considering the setback is there for what I believe Brian answered was for fire regulations to make sure there's enough space, whatnot. Considering the fact that there's nobody back there, it's a common area. I walk there every morning and I actually see this particular lot. There's like a small iron gate that's back there. Is there any way that these could be made for like permanent exceptions when there is like there are absolutely no back neighbors back there? There's no fire hazards. There's no, so this doesn't become per se a bigger, or people asking constantly to do something on their private property.
Naeem, are you talking about giving staff the ability to say if there's nobody behind you that they can make this approval?
Right. But I can completely understand if there's a fence back there and there's a neighbor right there behind them, you know, that could potentially pose an issue, and I agree with that. However, in cases like this, where there's either a retention pond or a street that happens to be, if I'm not mistaken, the street, I think it's like 15 feet away from that gate. So there is no real posed risk of anything other than just asking the government for permission to put something in their backyard or to keep something that they already have in their backyard.
I think that's a great thing to direct staff to look into, maybe at the end of the meeting tonight during comments, and ask them to explore that possibility. I think probably in a situation where a resident has expressed concern, staff would probably push it to the P&Z anyway. But if you've advertised it, there's no neighbors that have any concerns, there's no neighbors behind, it's certainly something that this board may look at pushing to staff and giving them the power to make that decision. But that's not going to affect your decision here tonight in this issue.
And then the other question I have is Northfleet, that country way is HOA, correct?
Yes.
And the HOA have they already agreed to this? Because this is an actual visual. This is visually impacting the HOA. So I was kind of wanting to ask that question.
Yes,
Because okay, so the HOA's already approved it.
yes.
With their visuals. Okay.
Okay. Any further comments or questions?
I actually have a comment or question. The two neighbors that are on my side at the cul-de-sac, both of them, I've spoke to them about the shed, and neither one of them have problems with it. I was concerned that, is that letter that who sent something in, is that permanent record so I can see who had issues and we can work through that?
It is in the packet that was emailed to you.
Okay. Thank you.
It's right after the public notice divider.
Perfect. Thank you.
Okay. Are there any further questions or comments before we call for a vote? Okay, seeing none, we do have a motion properly seconded to approve resolution 2020-42. So we'll call for a vote, beginning with Chair Baker.
No.
Gavin,
Yes.
Naeem,
Yes.
was that a yes?
Yes.
Okay.
Aye.
And Bill,
Yes.
motion passes 3-1 with Chair Baker in dissent. Thank you, Ms. Jones, for being here tonight. And that will move us to.
Thank you for having me.
Absolutely. That'll move us to item 3, which is a petition to allow the placement of a permanent accessory structure in the side yard outside of the permitted building set.
You have to announce that it will go before the Board of Adjustment on September 28th.
Thank you. This will go before the Board of Adjustment on September 28th. Give me that time date for the next 2 as well, Ms. Jean, since I'm having a copy off of something else. I can get my packet. This is also a quasi judicial hearing. Brian, do we have anybody new enter the waiting room since the last time we went through our quasi judicial proceedings?
No, Mr. Mayor, we have not.
Okay, then I'm going to go through ex parte for resolution 2020-43. Chair Baker, you have any ex parte to?
No, I do not.
Gavin? I did. Gavin, you're on mute. Do you have any ex parte?
I have none.
Okay. Naeem?
No, Mr. Mayor.
Bill?
No.
Okay. No ex parte. All the staff members, I think we can swear all of you in at one time. So if all the staff members could raise your hand, if any
Mr.
member
Mayor,
of the public, Bill?
I think the Busserts are on the line and they started to swear in at under the last one. So I think they do want to be sworn in for this one.
Okay. So Ms. Busser, go ahead and click the button. We're going to swear you in as well. Is there anybody else on the line with their hand raised that needs to be sworn in for resolution 2020-43? Okay. Mr. Attorney, if you would swear everyone in, please.
I certainly will, Mr. Mayor. And then following that, I'm going to read the resolution in. We've already referenced as 2020-43. We do have, I think, the staff. We've already had them state their names earlier, but for the record, could we have the applicant who plans to testify state your name for our record, please?
Yes, Jonathan Bassart.
Okay, thank you, Mr. Bassart. And if you could raise your right hand, and you hereby solemnly swear to tell the whole truth and nothing but the truth.
I do.
You're all duly sworn. Mr. Mayor, if I might, I'll go ahead and read the resolution. Resolution number 2020-43, a resolution of the City Commission serving as the Board of Adjustment of the City of Newberry, Florida for approval of a variance petition is authorized under section 3.2.5 of the City of Newberry Land Development Regulations, providing for location of a permanent accessory shed structure within the side yard east side extending into the minimum side yard setback area on the east side of lot 195 of the Newberry Oaks Phase 9 in the RSF2 residential single-family zoning district as provided for in section 4.2.4 on certain lands within the corporate limits of the city of Newberry, Florida, repealing all resolutions in conflict and providing an effective date. And here the board's motion would be to recommend to the city commission serving as the Board of Adjustment the passing of resolution number 2020-43 as read by title only, or passing it with conditions, or denying the application.
Okay, thank you, Rich. As before, we're going to start with a staff overview. Is that going to be Wendy again, or Brian, you taking this one? All right, Wendy, go ahead and give us the overview.
So this is an application for a variance to allow placement of permanent accessory structure in the side yard and outside of the permitted building setback line. This map shows the location of the property on lot 195. It backs up to the drainage area in phase 9 of Newberry Oaks, which is.
Is anybody else not seeing the map?
Are we supposed to be seeing the map at this point in time?
Yeah, I'm showing you my screen. Are you seeing it?
We're not seeing it.
No.
Oh, you're
Okay.
just the overview. So
Hold on a second
hold on
here.
1 second.
Um,
I know that you hit share screen, then gives you like 9 options. You got to find the right
Yep.
one. Trust me, I'm
Okay.
all about the share screen thing,
Star.
virtual learning.
Presentation has disappeared. All right,
Brian, have you got it?
let me see.
I don't. Well, there
All
we
right,
go.
that's the other one. That's, I don't know. It's
I see it now.
That's
40, not 43.
that's the previous. Okay, let's see what's going on here. Brian, are you showing?
You're still, there's nothing on the.
It just says that I do not have the ability to share my screen.
Dallas, did you deny her the ability to share her screen?
No, it's still set to allow outside.
Let's try this again.
Wendy, can you email it to Brian? And Brian, can you pull it up?
So
Is this right?
you cannot see it now?
Yep, we got it
There
now.
you go.
Looking at lot 195. Is this where you want to be at in your staff overview? We can see your PowerPoint now, Wendy. I don't know if you're on the slide that you want to be on.
Okay,
Lot 195.
okay. So
Let's start all over.
I'm so sorry. Let's see.
No worries.
Okay, here we are. Back at, this was this slide that I was just showing, lot 195 that backs up to the drainage area in Newberry Oaks, which is on the north side of State Road 26. The application is by Jonathan and Susan Bussart, and they are requesting a variance to the zoning district to allow for a permanent accessory structure, a shed, be placed on the east side of their house, abutting their house directly, such that it would be in the east side yard and then extending into the side yard setback, the required side yard setback of 10 feet. And it would bring it down to 4.75 feet. It's on lot 195. It's about almost a quarter of an acre. The purpose of the request, as I said, is just this is a new shed for construction of the shed, which would be a permanent structure on a foundation, such that it would end up taking that side yard and extending so that it would be 5.25 feet that goes into the side yard setback area. This shows you the overall plat, the location of lot 195. And this is just an illustration I had on the other one too, that if we need it to kind of explain setbacks, that we have that. We're talking about property on the east side that would be in the setback area. So I'll leave it at that with that slide. If that would conclude our introduction to the application.
Thank you. Wendy. Mr. Broussard,
Yes.
would you like to make an presentation?
Sure. I'd just like to speak. I don't have a formal presentation. What's in the packet but isn't shown here is we are actually currently under construction to have a swimming pool installed in the rear yard, which doesn't leave any room for a shed, really. The side yard really makes the most sense in terms of accessibility around the property. And on the west side, we have a drainage easement, which I just assumed we couldn't build over that because there is a storm pipe that goes under the side yard there. So the only option really for a shed on my property is the eastern side lot. Now I have, since I applied, I've talked to people and I understand that there needs to be a change in the size of the shed to maybe hit a minimum 5-foot setback from the edge of the property. I'm certainly willing to make any adjustments. This is just an approximate size for the shed. So I'm open there. And I guess the other concern was as the shed would be a permanent structure, it would have to meet fire code, which I fully understand and would comply with. I was essentially going to build the shed in the exact same construction the home is built to include even finishing the interior walls if necessary. So again, I'm open to work with the building department on any aspect possible, but I'm kind of pigeonholed here. That's really the only place I have left on my property that I can put a shed at this point.
Okay. Thank you, sir. Is that you'll have plenty of other opportunities throughout this procedure to address the board, but does that conclude your presentation?
It does. Yes, sir.
And let me start by thanking you for not just putting that shed right on top of that drainage pipe and through the process. We do appreciate that.
No problem.
Yeah, I have not been contacted by any third-party intervener for this item as well, so that's going to move us to public comments. So, Brian, if you would put our phone number.
Mr. Chair?
Yes, ma'am. Oh, I'm sorry, staff report.
Do you want to hear the?
Trying to skip you. I apologize, Wendy. That will move us to the staff report and staff's recommendation. Go right ahead, Wendy.
Okay, well, let's.
Really fast.
Okay. All right. Well, Mr. Bussard had just shown you the application, the actual site plan that he had submitted with the application. So, and he showed you where the new pool and deck that they currently have under construction and where he plans to put the shed. And you can see that on the east side. Again, these are the regulations that the code has for the Board of Adjustment and for your recommendations, for your consideration when recommending to the Board of Adjustment approval or not of an application, that it must be in the public, not contrary to the public interest, and that it would not result in undue hardship to the property owner as a result of our regulations. Again, the authority is there with the Board of Adjustment. The conditions that you may prescribe conditions based on your recommendation for the approval, you may deny or approve without conditions. It is prohibited for the Board of Adjustment to grant any permit variance for something that's expressly not allowed in a zoning district or by implication prohibited by the land development regulations in that district based on a hardship. And we don't want to deprive the applicant of rights that other properties would enjoy, and it will not be contrary to the public interest, and in particular that looking at this particular property and making sure that it's not the result of actions of the applicant. The minimum possible variance would need to be granted if such is approved, and that the variance would not be contrary to the public interest. And of course, the section about if someone wanted to apply again in the future for the same. The recommendation of staff is for denial of the application, with the recommended motion being to recommend to the Board of Adjustment denial based as presented by staff. Now, we do have in your packet the resolution, which is written for approval, and I do have slides for that. Should you want to go in that direction, we do have that before you with conditions for that particular application. If
Okay,
you'd like, I can go through those or not.
does the board want to go ahead and hear what the conditions would be if you want to go in, or do you want to have a conversation and then go backtrack?
I'd like to hear Wendy explain just one more time why they're recommending denial, if you can just summarize that.
Okay, Wendy, why don't you go through that again, and then can you just summarize the other path the board might take? And then if they're interested in that later on, they can ask you for greater level of detail.
The recommendation is based on the area that is still remaining on that site, the fact that it's a pool and patio area that's being constructed, and it was felt that looking at the site plan that there would be area in the rear yard to place that shed. When you look at the drawing, you would still encroach into the side yard and rear setback, for which they're asking, variance now. So looking at this area here, looking at, you've got 15 feet. If this is the area that they've proposed as they show on their site plan, and then you've got a fence back here, and then you do have this area, would it be possible to look at that? Based on the size shed that they're proposing, it appears that it would fit there. So the recommendation is based on that configuration, and also the concern about having a shed that's less than 5 feet from the inhabited structure, which, as Mr. Bussart said, it brings in the code for the separation requirements for fire safety for the 1 hour firewall. And so they would have to meet that. Typically, it's not encouraged, but if, like Mr. Bussart said, that if he were to meet all of those requirements, then that was one of the conditions of the recommendation. If you were to choose to go for approval, that you would need to do that. It does show that, last thing would be looking at the aerial to see where they're located. You're talking about, of course, these are the shadow areas, but you see with the roof, from roof overhang to roof overhang, just kind of getting an idea. This is their property line. You just they're not perfect on these aerials. So just to give an idea that if you're putting your shed in here and it's going to be less than 5 feet from the property line. Or, yeah.
Okay.
That help, Annie?
You want to give a summary of if the board wishes to go through, staff would recommend.
Yes.
For us quickly.
If the application were to be, if you were to recommend approval of that application, it's just, at this point, the conditions are written based on the application, that it would be for a 10 by 12 accessory structure. This is a permanent structure, that it would be constructed as he's shown on his site plan, and then just conforming to those, that location with the recorded plat, and not encroaching greater than 5.25 feet into the setback area. And then, as it's shown on the site plan, then the permanent accessory structure would have to meet the minimum 1 hour fire separation requirements according to the fire code, and then obtain any necessary permits. And that would be the recommendation if you were to go that route.
Okay, thank you. Now, I will make the comment that I've not been contacted by anybody wishing to claim a third-party intervener status. So that will move us to public comment. So this time, Brian.
Mr. Wright, I just wanted to add maybe a little bit of clarification from staff's perspective as well. I mean, we don't ever like to recommend for denial. Of course, we try to find a way to make these things work within the code. On this particular instance, that I think this is like only the second or third in 6 years that I remember. In this particular instance, the commission had granted staff the administrative authority to allow temporary accessory structures in the rear yard to go within the setbacks up to 5 feet to the property line. This being the side yard, that we don't have that ability to do that administratively, but also two, the fact that it's going to ultimately be a permanent structure and not what could be considered a temporary structure like most of those sheds are. That also changed the consideration as well. And as Wendy alluded to, we felt like there was adequate space in the rear yard. Again, it would probably require possibly require a variance to go closer to the rear setback, but similar to the Jones case, in this instance, they back up to a basin. And so we felt like that there was a much greater chance of a successful variance application for the rear yard placement as opposed to directly adjacent to the house and encroaching further into the building setback lines.
Okay, does that conclude staff's presentation? And staff's official recommendation is for denial, just for clarity's sake. Okay. Again, I have not been approached by anybody wishing to claim a third-party intervener status, so that's going to move us to public comment. Brian, if you would please put our phone number on the screen. Ladies and gentlemen, we are on item 3 on the published agenda. This is about a petition to allow placement of a permanent accessory structure in the side yard and outside of the permitted building setback line. If you wish to call and address the board on this agenda item on resolution 2020-43, all you need to do is dial the number that's on your screen. Once we get you into the meeting, at the bottom of your screen, you'll see a little hand symbol. Click that symbol. That'll let us know that you'd like to address the board, and we'll make sure you have the opportunity to do so. Again, we've got about a 30-second delay between our live feed and the YouTube feed. So we're just letting a little bit of time pass here to make sure that anyone who wants to address the board isn't denied the opportunity to do so. Brian, do you have anyone with their hand raised? No?
Well, Mr. Mayor, we do not.
All right. Well, you take us back to the board members. Okay. Mr. Broussard, did you hear anything in the staff report that you'd like to cross-examine? This is your opportunity to ask Wendy or Brian questions directly about anything that they've said to the board.
Sure. Not necessarily a rebuttal, just a comment regarding the rear setback. Even if I was allowed to encroach to within 5 feet of the rear property line from where the edge of the future pool deck will be, that would leave just enough space for just the shed. It would butt up to the screen enclosure. Then I'd have no way to access part of the shed as it was. And I'd have to actually use part of that 15-foot setback if I can only go up to a maximum of 5 feet. Now, the only other option would possibly be the northwest corner of my property, which is there's more of an open area there. We did have future plans for an outdoor seating area, but if it's not in the cards, it's not in the cards. But I could possibly put a shed there. It's not ideal because it's right in sightline of the new pool we're putting in. And then I still have to deal with the foundational issue because as I understand it, the current code allows for a temporary structure, not a permanent structure, to be constructed within the setback. So my hands are still tied there as well. So if that would be a possibility for a permanent structure to be built in that northwest corner and encroach upon the setback because there's a retention pond there, that's something I may be open to. It's not ideal, but again, ideally the best place for my family would be on the side of the house as planned. And I'm certainly willing to change the dimensions of the shed so I don't hit a maximum of 5 feet into the setback or whatever needs to be done. But again, that would be ideal for my property and my family.
Okay. Thank you, sir. Staff, did you hear anything in that you want to cross-examine? Did you want to ask Mr. Broussard any questions based on his presentation or that comment?
No. Brian, did you have anything? Are you?
He's
Okay.
shaking his head no.
Okay.
Okay.
Yep.
That will move us to members of the decision-making body who through the chair can ask questions of the staff or the applicant. Okay, board members, do you have any questions? We can go back and forth, either question for staff or the applicant, or we can focus on staff first. Naeem, was that a hand?
Yeah, I have a question for staff. Since hearing of the applicant stating that, this isn't completely built yet, whatnot, he's trying to work. It seems like he's trying to be reasonable here. with it being like, what is it, about a half a foot away from what we legally would require? Is that what I'm adding up to here?
I think
Mr. Chair, the 5-foot setback is, refers to, and it applies to only temporary accessory structures. Otherwise, a permanent structure has to comply with the normal setbacks for the property based on their zoning.
And in addition to that, it only applies to rear yards. This is the side yard.
So it only applies to rear yard. Well, the reason I was getting at is, you know, a 10 by 12 shed, you know, it sounds like the applicant's trying to be pretty reasonable here. I mean, if we were to suggest maybe something like an 8 foot by 12 shed, would that be something that staff would be more considerate on the fact of that you guys would consider for approving? You know, given some more room? I mean, because I can understand what the applicant's stating with the whole new pool, it coming up to the screen. So I just wanted to see what staff's recommendation is. If he were to, maybe not, the length being 12 feet is fine, but the width being 10, maybe shortening that a little bit.
Mr. Chair, I think it boils down to if the building setback, it's not just that we're allowing a temporary structure in a side yard or a temporary structure within the building setback lines, but then the fact that it's a permanent structure that exceeds the building setback lines by 5 or more feet. When there are potentially other viable options that would not violate the building setback lines. We are certainly sympathetic to the applicant's desire to place it where he would like it to be. But the preference would be not to violate the actual building setback lines and set that precedent potentially for future variance applications of a similar nature.
just for clarity's sake, Brian, because I think the crux of Naeem's question, we all are on the same page. If the shed goes from 10 foot to 8 foot, how much does it encroach on the setback at that point?
At that point, it would encroach within the setback lines by approximately 5 feet. The actual building setback line is on the side lot is 10 feet. And so he only looks like has about 5 feet to work with from the edge of the building, the house, to the building setback line. And so anything over that 5 feet is still going to be an encroachment.
Okay. All right. Does that conclude your questions, Naeem? Okay. Other questions from the board to staff or the applicant, Gavin?
Yeah, I think what Naeem is pointing out, so if it were a temporary structure, we wouldn't have that same issue, but because it's a permanent structure, the requirements are different.
I think
no, Mr. Chair. Sorry.
I was saying, I think it's more about being on the side of the house instead of the back, right? I mean, it's the temporary versus permanent structure also changes the nature of this, right?
Yes, Mr. Chair, it's a combination of both. The fact that it's in the side yard, which the commission did not approve violating the setback without a variance there. If it was in the rear yard and it was a temporary structure and it was within 5 foot for the property line, it would be acceptable, side or rear. But being that it's in the side yard, which was not part of the commission's not discretion, but the direction to change it to allow for within 5 feet. That was strictly from the rear of the house back in the rear yard. And so that's the other part is we're contemplating allowing a permanent structure within the side yard to exceed the setbacks by.
That answer your question, Gavin?
It does. And Brian, can you or Wendy just confirm what is the existing distance from the house to the property line?
You want to do that, Wendy?
If I'm not mistaken, it's 14.75 feet, if I'm correct.
Okay, and Brian, we're expecting them to keep a 10-foot clearance. That's right.
Sorry, what was the question?
We expect them to keep a 10-foot clear path. So basically, we tell them they can build a 4-foot wide shed to be compliant as is. I just want to make sure I'm understanding what.
Well, you have another issue because you have to have 5 feet of building separation if you were to have a permanent structure between that structure and the home.
Okay.
5 foot in unless.
Or if you don't, it's right, if you do not meet the
1 hour
code.
fire separation requirements.
That's correct. And Mr. Bussart was saying that he would do everything, he would do whatever was needed to meet that requirement.
Okay,
Mr. Mayor.
other Naeem.
I'm still kind of perplexed on this because back to Gavin's point here, the applicant has 14.75 feet between his house currently to the fence line. There's plenty of houses, quote unquote, especially where I live, that the setback from my house to the fence is 5 feet. I mean, literally 5 feet. And I know we made special exceptions and whatnot, but this goes back to my train of thought of if we were to ask the applicant to maybe shorten it to be in that 5 foot threshold between the fence and his shed, what makes him any different of even that being a permanent structure? What makes him any different than what's currently existing in Newberry as we speak?
Primarily, Mr. Chair, the answer to that would be that in staff's assessment, there's no demonstrated hardship not incurred by the acts of the applicant. There appear to be other viable alternatives. And so for that reason, rather than recommend for violating the land development regulations, staff unfortunately recommends for denial. Each neighborhood is different and has its own, depending on the neighborhood, has its own set of setback requirements. But this particular one is side yard setback of 10 feet. So.
Okay, does that include your questions, Naeem?
I mean, it does. I just feel the frustration, honestly, because I feel like the applicant's trying to work and with us, and I want to work with him. You know, it is his property. He is trying to comply with fire codes, and I think that's the most important part here. Is if fire codes are saying one thing, but we're going off of setbacks and other places in Newberry, you know, are being having exceptions for this. You know, I kind of feel bad that this guy moved into this place, and unfortunately, his setbacks are 10 feet, not 5 feet. So you can't do anything about it.
I think you'll be able to make that argument in deliberations. So if you want to pitch that. Bill, were you raising your hand? You have a question?
Yeah, just for clarification, and I hear what Naeem's saying is we have some subdivisions where we have 5 feet. We even have 0 lot line subdivisions, but that's only on one side. You can have 5 feet on one side, but somehow you got to get 10 feet in between 2 houses so the fire department can get in there and work. And while he may have 10-foot setback, his neighbor's only got a 5-foot setback. So if he goes into that area, now you don't have enough room to get a fire truck through there or for fire equipment to get in there, especially if it's a permanent structure built on a slab. So I'm going to agree with the staff that we've given a lot of variances for setbacks in these small lots, but in this case, he's squeezing the 10-foot space that fire department needs to get in there, and building it to fire code isn't going to solve that problem.
Mr. Chair, if I may, what's the footage on the neighbor side then?
What was that question? What's the footage on the neighbor's side?
Right. Like how many feet? He has 14 feet on the neighbor side too? No.
This has to be that by the time you go around, you can squeeze a little more on one side, a little less on another. But you can't both do it together at the same time. That's my general understanding.
Because I mean, I was looking at the aerial view that Wendy showed us, and it looked like there is, obviously there's not, measuring tool on there, but it did look like the lot 196 that lines up next to lot 195. It looked like that neighbor also had a 14.5-foot setback already too. So that's where I'm saying, you know, I'm a little perplexed on the fact of the guy wants 8 feet from his house. He's still going to keep a 5 foot from his new permanent structure to the fence. There's still going to be enough room, even if the neighbor decided to do his own shed on the other side and only be 5 foot from his fence. So there's still 10 feet there.
Brian, can you answer this question about the neighbor setback on that side once and for all? The other and I'm not sure if
On lot 196,
yeah, how
according
much
to the map.
setback for that property?
Yes, for sure. I mean, all of the homes in this particular neighborhood have a 10-foot side setback. And so there's going to be a minimum of 10 feet. We don't have it in front of us what the distance from the property line to the actual structure on the adjacent lot would be. But we do know that there's at least 10 feet because that's what the minimum building setback line is.
Okay. Are there any other remember, we have a whole other section of the quasi judicial where we have to deliberate and then we get to make arguments and those kinds of things. Do we have any questions that will advance those deliberations later for staff or the applicant?
My question is, have we ever approved a similar request before that falls under these same issues that we're?
Have we, I think what you're asking, Gavin, have we ever set a precedent that would allow in this neighborhood, in these conditions? I don't know. They might need to do some historical research. Wendy's shaking her head, not in her memory. I can't remember in my memory allowing a side setback like this. Wendy?
I don't recall any side yard. I looked back through past variances, but when I was looking at this one, staff was talking about it, I didn't see any previous side yard setbacks because typically it's always been with the rear yard and people aren't, were not requesting it because it wasn't something that the commission wanted to do at the time. So I don't have any old past ones that I can rely on.
Wendy or Brian, did we reach out with a phone call or an email to the applicant and discuss the problems with the permanent structure versus the temporary structure? Was there a reason in particular the applicant feels like is it just an aesthetic? I want it to match the house. I want it to be a permanent structure. Do we have that conversation with the applicant?
Wendy, can you?
I have not directly had that conversation. It was relayed to me that the gentleman had was interested in doing it, that it would match the home, that it would be a permanent structure and have that appearance. If he wanted to make it that kind of quality.
One of the things I want to avoid here tonight is we may get into, well, we could do it in this,
Right.
we could do it there. Would the board approve that? No one here tonight is prepared to say whether we could or we couldn't. We haven't agended it. You guys haven't done the background data. So tonight, if the board is against the side, this question, then the applicant's going to need to start all over with a back corner application. Okay, so I want to preface that because I can already see people throwing out, well, we can do this, we can do that. I've heard the applicant say there may be another option. It's not ideal. I want to make sure everyone's clear that tonight we're just looking at the application that's in front of us for the side setback. Are there any other questions of staff about this?
If I might, you do want to consider the part about in the regulations that reference if a decision were to be made, the need to wait for another 12 months before a similar application can be made, unless there's some other hardship that's caused by that, or some other different kind of application. It might be, if the applicant were open to it, worth exploring together with the applicant, looking at that property, getting with our building official and seeing if it would work to do it in a different location, or if the applicant has already looked at that more closely, or if you'd like to.
Wendy, if we haven't had a conversation about the side, usually when we allow sheds, permanent or temporary, to go on the side, there is some condition about putting a privacy fence in front of it, something that hides the shed from the road view. Did we have any of that conversation with the applicant? Or if the board decides to do this, they could put that condition in, or that ship has sailed?
I actually marked that up on my plan and annotated where the new fence would go in conjunction with the shed being built.
Okay.
Right, and
New
I
fence
can, you
installed.
can go back and look at that if you would like.
All right.
Board desires.
Any final questions before we move to final arguments? Okay, hearing none, then we're going to give the applicant the ability to make the first final argument based on all the conversations, sir, you've heard here tonight, the questions and the comments. It's a chance to make one last appeal, what you can do to address some of these current concerns, that kind of a thing. Would you like to make a final argument?
Sure, and I'll be brief because I know it's getting late for everybody. So what I propose is as was discussed, I would be more than happy to narrow the width of the shed to 8 feet or somewhere approximately that range, which would certainly provide more than 5 feet from the property line to the edge of my fence, giving my half of the 10 feet required for a fire department if they ever had to come through. And then if my neighbor ever decided to apply for a variance, they would probably, I'm assuming, fall into the same conditions to guarantee we had 10 feet between our properties for fire safety code. Aside from that, as it was mentioned again, that there may be a possibility of somewhere else on the property, but again, given location of all the new construction, the pool and everything else, essentially I have one plot of grass to put a shed in my backyard, and my backyard is going to be full. There's no room for my dogs, no room for my family, anything else. So that's kind of a last ditch emergency effort if I can't make this happen, but I really see no reason why we can't make this happen, especially considering that I'm willing to meet all fire code, building code. I work in commercial construction. I've been doing it for many, many years, so I have no issues with that. It's just, that's where I stand. The side yard is where I really need to be. That's kind of where I'm at.
Okay, thank you, sir. Staff, is there any final argument you'd like to offer the board? You said it all. All right, we appreciate that. Mr. Attorney, would you please advise the decision-making bodies to the applicable law and the factual findings that must be made to approve or deny the application?
Certainly, Mr. Mayor, similarly to the variance that was discussed on the prior item, we're again governed by the substantial competent evidence standard, taking into consideration all of the evidence and testimony that we've heard, and factoring in the various elements under section 12.4 of our LDRs that Ms. Wendy had walked us through.
Okay, thank you. I guess, Rich, the final question that maybe the applicant should consider is that we are down one board member tonight. We've had two board members that have been relatively quiet on this. One have expressed support, one has expressed objections. Should we give the applicant the potential to delay this? I should have probably asked this at the beginning of this until we have a full board, and just in case we end up with a tied vote, that would make the application would fail at that point, correct?
Yes, it is an option under our quasi-judicial procedures. Section 7 addresses continuances, and it says that the decision-making body may, on its own motion or at the request of any person, continue the hearing to another fixed date, time, and place. The applicant does have a right to one continuance, and then all subsequent continuances are granted only at the discretion of the board. So the applicant could ask for a continuance.
And what I would advise the applicant then is to listen to the deliberations that are about to occur. And if you would like to ask for a continuation, then before I ask for a vote would be the appropriate time if you don't think the conversation is going your way.
Understood.
Okay. All right. That will take us to deliberations. It'd probably be helpful to the applicant to hear from some of the other board members their thoughts about this. Chair Baker.
Mr. Mayor, I have some of the same reservations for this application as I did the previous one. While I sympathize and can understand the concerns of the property owner, I think some of the issues are of the property owners making, and under the criteria that we are to review in order to grant a variance, it makes it difficult to approve it because not all the conditions are met.
Okay. Gavin? Do you have any deliberation, any final thoughts?
My concern here is not of appearance, but of maintaining safety, not only for the property owner, but for their neighbor. And so I think that's how I would make my decision.
Okay. Naeem, did you want to make one last appeal to your fellow board members for any potential compromise here?
Just to reiterate again what Gavin just said, it's really a safety concern, and if we're in safety compliance, I don't see an issue. I don't think there should be an issue. Safety is a non-negotiable in my book. But if we have an applicant that's really willing to accept that and help to move that back a little bit, I don't see why we can't look into moving forward and at least with the conditions.
Mr. Broussard, it doesn't sound like this is going to go your way tonight. In order for us to not get into the situation where you have to wait 12 months to bring this forth again, I would offer you the opportunity to ask for a continuation. It sounds like you have 3 board members who have concerns. I can tell you the 5th board member who's not here tonight is also kind of a stickler for these kinds of issues as well. But the continuation may give you the opportunity to go and sit back down with our staff and come up with a plan that would get their recommendation to approve. Would you like to do that, or do you want to?
Absolutely, I would. And also, would there be a way to request a physical face-to-face meeting where we can actually discuss and either outside of my property or at the building department to try and work through this? Because I'm sure there's a solution.
And generally, I find if we can all get on the property and walk around and kind of talk it out and see what we're trying to do, we can come up with a compromise situation that we can all get behind.
Okay, I'd be open to that.
So are you, as the applicant, asking for a continuation of this? You're asking the board to table it?
I am asking for a continuation based on our discussion.
Okay, Rich, is there anything that we need to do as a board? Do we need a motion to table it?
We actually don't need a motion because the applicant is entitled to it as a matter of right. However, we do need to set a fixed date, time, and place, or at least a fixed date. Do we have a tentative planning and zoning meeting scheduled anytime soon or in October?
October 3rd?
Is that enough time for
October
everybody?
5th.
October 5th? Is that enough time for all the parties to get together and talk this through more?
I'll reach out to Mr. Bussert tomorrow and work on scheduling a meeting with all the parties, including the building official.
How does that sound, sir?
That's perfect to me.
All right, well then we appreciate your time tonight. Sorry we couldn't bring this to resolution tonight, but I think in the end, hopefully we'll have a product that we're all happier about and glad that we took the time to get it worked out. So thank you for being here with us tonight, sir. Hope you have a wonderful rest of your week.
Thank you everyone for your time. I appreciate it.
Thank you.
Okay, that's going to move us to item 4. We have nothing left with that one, correct, Rich? Moved it to continue. We set the date. So item 3 is complete. Rich, would you go ahead and read resolution 2020-XX? I've never seen that before. Into the record for us, and then I'll ask for swearing in and ex parte, since I saw how nervous that made you that I did that first last
time. Thank you, Mr. Mayor. And I will apologize. I don't know that the city attorney has the agenda packet on this item. It may have been emailed over to us today, and I apologize if we're overlooking that. I do have the staff report.
Brian, do you have it?
Mr. Chair, this is one that I need to ask the board's indulgence on. It's an opportunity that sprang up at the end of the week last week. And so we've been working with the applicant to get as much information together as possible. It only came together late this afternoon. And so with your indulgence, I'll put up the staff report on the share screen so everybody can look at it. It literally kind of came together about 15 minutes before the meeting started. And if it wasn't for the fact that it's a somewhat of an exceptional opportunity, we would have followed standard procedure. But it's a time-sensitive opportunity that we didn't feel like we wanted to potentially miss.
So in that regard, Mr. Mayor, I do have the title and I will read that in at least for the record.
Let's read it by title only and that'll get us started.
Resolution 2020-XX/STUP 20-03, an application for a special permit for a temporary use to allow a one-time outdoor concert as provided in section 14.10.1. Temporary use permits issued by City Commission of the City of Newberry Land Development Regulations to be held October 23rd, 2020 on property approximately 216 acres in size located adjacent to the Alachua County, Gilchrist County line on the southeast corner of West Newberry Road, SR 26 and Southwest 298th Street, Gilchrist County Road 2085 and Southeast 90th Avenue.
Okay, thank you, Rich. Once again, if we could have all staff, and if the city here is the applicant, or is Sister Hayden?
No, Mr. Mayor, Pat Post is owner of the property, is the applicant, but again, we didn't have quite time to get the usual paperwork in terms of the affidavit signed for the agent, but the agent in this instance, Mr. Phil Benito, is on the line, and he can speak to the application at the appropriate time.
Benito, if you could, we're going to go ahead and swear everybody in. So if anyone who is here tonight that may speak on this application, if you could raise your hand, I'm going to ask the attorney to swear it in. The city staff have stated your name, and am I saying, I don't have a name on my screen. I just have a number. Is it Mr. Benavito? You have to unmute him at the time.
Unmute.
There we go.
If we get you on.
Okay, sorry about that. Yes, it is Phil Benito.
Phil Benito. Okay, if you could state your name when the attorney swears you in. Rich, would you go ahead and swear everybody in, please?
And please raise your right hand. And do you hereby solemnly swear to tell the whole truth and nothing but the truth?
I do.
I do.
You are duly sworn.
Thank you all. And board members, I need to ask you for ex parte communication on this agenda item, started with Chair Baker.
I have none.
Bill?
None.
Gavin?
None.
Naeem?
None.
Okay. Everybody has been duly sworn. We have no ex parte to disclose. The resolution has been read into the hearing. Brian, do we have anybody new enter the meeting since we began?
No, Mr. Mayor.
All right, then we will go right to the staff overview. Wendy, is this one you as well? Brian?
This one is me.
All right, go ahead.
Okay, thank you, Mr. Chair. As you're all aware, the city, due to the pandemic, had to cancel its Westfest Music Festival this year, the headliner of which was going to be Sister Hazel. Everybody was very excited about that, but unfortunately, it did have to be basically canceled until next year. However, in the meantime, we have an opportunity. Sister Hazel has requested that they be allowed to do their annual concert at the mine. Although in this instance, it wouldn't be down in the mine; it would actually be in a field on the above, the level ground and adjacent to it, on a much smaller section and a much smaller potential venue. Basically, what they're proposing is that it would be a drive-in concert maximum.
Ryan, your audio just went way down. I don't know if you leaned away from your mic.
No. I can change mics though if it's a problem.
There it's back.
That's back? Okay. Basically, what they're proposing is that they would have a maximum of 600 cars, and it would be kind of set up like a drive-in concert, and the cars would be separated appropriately for social distancing between the parties. And then once in the facility, parked in the facility, they would, the occupants of the car could then get out and set up chairs in front of their vehicles and watch the concert. It's a much, of course, smaller event because it's only one band. I think it's one band, but it would run from approximately, they would open the gates and start allowing cars in for parking at about 6 o'clock on a Friday afternoon, October 23rd. And they'd be wrapped up probably by 10, but just for a little bit of a fudge factor, they're asking for 10:30. And we're working with them to modify the existing life safety and emergency operations plan that was developed for the larger event. We're working with them to scale that down to an appropriate size for this event. It's not quite done yet, but it'll be complete before it goes before the Board of Adjustment with the blessing, of course, of the fire chief. The traffic will be handled by Alachua County Sheriff's Office. They'll also have a couple of officers patrolling in the event for security. They will have a couple of food trucks, vendors on site, but they are not going to be serving any alcoholic beverages. It would be strictly regular food and drink, soft drinks, whatever. Then, like I said, it would end at about 10 to 10:30 at the latest, and that would be it. Again, it was something that came together at the end of the very end of last week, and so I apologize again, and hope the board can indulge us in trying to get something together as quickly as we could that encompasses the majority of the facts, and then the fine details in terms of the safety plan and that kind of thing, the traffic and parking, we're going to work out prior to the hearing with the Board of Adjustment. And so going a little further, it is on the property owned by Mr. Post. The supplemental information, like I said, the doors open at 6. Concert will start at 7:30, be a 30-minute break, and then the second set will start. Anticipated ending is by 10 to 10:30. You'll have a total possible occupancy of around 2,400. Mr. Benito has shared that they don't actually think they're going to get up to 600 vehicles, but that would be the maximum. And then up to 4 people inside of each vehicle. And if you had a larger vehicle that had a couple of others, the only potential for on-site ticket sales would be extra people in over the 4 people per vehicle. They would be an opportunity for a couple more on-site tickets. The rest would be sold online prior to the event to prevent the backups like we talked about with parking coming off, or the line of cars coming off of Newberry Road. They expect 2 to 3 vendors, like I said, no alcohol sales, potentially 2,400 attendees roughly as a maximum. The ingress and egress will be off the main entrance that currently exists going into the mine directly across the street from Southern Fuelwood's entrance on the north. The copy of the FDOT driveway permit's the same permit that was used for the previously approved special temporary use permit for both West Fest and for the Mines big event that was also postponed due to the pandemic. Again, traffic and security handled by the Sheriff's Office. As to noise issue, there is a potential for a little bit more of an issue for noise because it is not being held down in the mine area. It's being held up on level ground. It's approximately 1,800 plus feet to the nearest residence. There's only a small number of residences within a quarter to a half a mile. But again, because it's a smaller event, you don't actually think that when you get out to the property line where the measurements would be taken, that it'll exceed the noise limits. But if that is a concern, that's another, you know, the city commission can grant a temporary waiver to the noise ordinance if they think it's necessary. They will carry $1 million or greater liability insurance. We're going to be working with the fire chief and also our rec director, Travis Parker, is working with them to take care of some of the other issues like the getting with ASO and traffic. As I mentioned, we are going to use a modified version of the existing approved life safety and emergency operations plan. There won't be any structural additions to the site. Nothing will be built on site. If they use a stage, it'll be one of those prefab stages that comes in on a truck bed and is assembled and then disassembled. So there won't be any need for building permits or building official inspections. However, of course, the fire chief and his crew would be doing inspections potentially on the preparations to open, and then they'll have a couple of fire department crew on site during the event. And as far as signage goes, the only anticipated signage would be during the event and directional signage into the event from probably from both directions. The actual footprint that they're anticipating using is much smaller again than has been anticipated for the much larger venues or events. Due to the scale, they only feel they'll need a much smaller area shown here. And then this just gives you the distance. This is roughly where the stage is likely to be set up, where my cursor is. And as you see, it's almost 1,900 feet to the front door of the closest residence. We do have signage up in front of the property to notify the public. And because of the notification requirements in our code, we will not be able to hear this on the September 14th meeting by the Board of Adjustment, but it would be heard on the September 28th Board of Adjustment meeting. And in between, we would have time to go ahead and put the required public notices in the paper and meet the other public notice requirements and have all the other details, the finer details ironed out for the emergency plan and such. That concludes our brief, but hopefully thorough enough staff report. Again, you know, we wouldn't normally try to you know, we wouldn't normally present something in this form to the board, but it's a unique opportunity, and we didn't want the city to potentially miss out on it.
So Brian, am I right? That was the overview, the report, and the recommendation coming in the form of a plea all at one time?
Yes, Mr. Mayor, that's correct.
Okay. Do we have an applicant presentation, Mr. Benevito? Did you like to say anything to the board? I know you probably don't have a PowerPoint to address them. Now
I don't have a PowerPoint put together. Brian summed it all up pretty well. The only thing is we actually do not plan on doing any on-site ticket sales at all. All the ticket sales will be done online. Okay. So, and we do have a plan to, as people come into the property, to set up queue lines off to the way you're looking at the version would be basically be between the left side of the perimeter and the tree line. There's approximately 40 feet there that we're planning on building queue lines that we'll be able to kind of get people in off the road, get them scanned in and their wristbands, and then they can, you know, we'll escort them into park at that point.
Okay. Okay. I haven't been contacted by anybody wishing to claim a third-party intervener status, but I wouldn't since this has been thrown together so closely to the end here. So that will move us to public comments. Brian, could you put the phone number up? Okay. So, ladies and gentlemen, okay, ladies and gentlemen, we come to our third and final quasi-judicial hearing for tonight. This is about an application for a special temporary use permit for a Sister Hazel concert at The Mine on October 23rd. If you would like to make a comment or address the board on this application, all you need to do is dial the phone number that's on your screen. Once we get you into the meeting, you'll see a little hand symbol at the bottom of your screen. All you need to do is click that hand symbol. That'll let us know that you'd like to address the board. We'll make sure that you have the opportunity to do so. Again, if this moves forward, there'll be another opportunity for public comments in front of the commission. I knew I was going to get to read that meme eventually. Okay, we have about a 30-second delay that we like to fill with memes here in the city of Newberry, just for your viewing pleasure. Do we have anyone with their hand raised, Brian?
No, Mr. Mayor.
Okay, we'll come back to the board. Okay, at this point in time, sir, you can cross-examine if you heard anything out of Brian that you disagreed with. Would you like that opportunity, Mr. Benevito?
No, I think he summed it up pretty well, I think.
Okay.
That was the main thing. I just wanted to make sure you understood we weren't planning on doing any kind of sales on site as far as, that being potentially a kind of creating a log jam there at the gate.
Okay. Great. Staff, did you have anything you want to cross-examine from yourselves?
No, Mr. Chair.
All right. Okay, we'll move to the members of the decision-making body who can ask questions of the applicant or staff. Questions from the board.
Mr. Mayor,
Chair Baker?
how far apart do you expect the cars are going to be parked? I'm trying to envision this in my head.
So the plan is basically to have 3 parking spaces per vehicle. There would be vehicle parked in one. Another one would be more or less where the people would be able to set up, some picnic chairs or lawn chairs and that sort of thing. And then another space that would be empty as kind of a spacer. And then the rows would be staggered so that people wouldn't be sitting, the cars would be staggered. I should have this, the parking chart done hopefully within the next day or two that I can share with you guys though.
I have seen some other renditions of this. You kind of rent a space and you get out. So I think I can kind of visualize what their idea is in order to keep everybody distant. But it would be, if this moves forward tonight, sir, you definitely want to have that before you come in front of the commission so that we have all the information.
It's actually, the designer has it now. I should have it within the next 36, 48 hours, hopefully.
Okay. Is that all your questions, Chair Baker, or do you have more?
That's my question for now.
Okay.
I was just saying, if you've ever been down to the Ocala Drive-In, I envision a similar setup to that. They've stayed open throughout the pandemic, and they've done it by, as they've described, having empty spaces in between cars, and then you have a row in between cars, and so everybody is well over 6 to 10 feet apart.
Yes, and it'll be similar. The way they have it set up is almost like all rows in this situation at the Post Farm would be more direct linear lines versus I think those have a little bit more of almost an amphitheater curve to the way that they had the parking situation there. If I'm understood the photos I saw of the Ocala Drive-In. So it'll be similar as far as the spacing, but it won't be, and the rows won't be rounded like that. They'll be more straight, kind of flush with the front of the stage.
Okay. Any other questions from the board members?
Yeah, I have a question real quick.
Naeem.
I have a question. Is there a reason why the October date is so pressing and why we have to make a decision so quickly?
Gavin, you're frozen. I called on Naeem, but it sounds like your voice. Who's talking? Is Gavin frozen for everybody or just for me?
He's frozen. I'm not sure if Naeem is frozen. Everyone's
I'm
frozen
not
right now.
frozen. I'm not frozen. I'm not frozen.
I can hear Naeem.
Just hold that thought. Naeem, you go, and we'll get Gavin unfrozen here in a minute. So Naeem.
All right, so I have a question now. So you say there's no alcohol sales, but is there going to be anything that you're not permitting, like bring your own alcohol?
I mean, we weren't, really discouraging coolers or anything. I mean, it was going to be kind of a, almost a pack your own picnic kind of situation. But we were planning on having at least a couple food vendors on site and, non-alcoholic beverages.
Okay, but there's no ruling on the fact of there's no alcohol at the venue allowed, correct?
We were planning, or expecting people to have, bring something, in a cooler kind of.
All right.
And obviously, I mean, the messaging of, yeah, I mean, the messaging of, responsible consumption and all of that, it's, we're expecting to have that, out there and messaged properly. We didn't want to get into the permitting situation with the alcohol, though, as far as doing on-site sales.
Understood.
Okay, Gavin, it looks like you're unfrozen now. Go. I think he froze.
Too soon.
No.
You want to type it in chat?
Yeah, can you type your question in the chat?
Or possibly turn off your video and then ask, and we might be able to get audio better.
That usually works for me, Gavin. When I'm at home, I just turn the video off completely.
Sure. Can the host accept my phone number, please, so that I can chat via the phone?
Brian, can you let Gavin in just through his phone number? You could also just turn your video off, Gavin, and see if that works.
Unmute him.
I think he's self-muted.
Did we let
Hey everyone, is it better?
We've got you now, Gavin.
Thank you. My first question is the date of the event in October. Is there magic behind that date? Why we're being forced to make a decision so quickly, or is it something that can be postponed so that we can have more time to submit a formal application and submit the notices that we typically require to all the neighbors?
Well, we are planning on a 3-night tour basically through Florida. So Tampa would be on the Friday, Tampa would be on the Thursday, October 22nd. Newberry would be on Friday, October 23rd, and Orlando would be on the 24th. We did switch Newberry and Orlando to the current situation because there was a possibility, the Gators are going to have a game on the 24th.
Okay.
And I don't know if that came into their new schedule that was posted a few weeks ago. I don't know if that's actually going to happen or not, but the band didn't want to, compete with that in any way.
Sure. And I appreciate what everyone's trying to do, and I don't want to let the city miss an opportunity like this. My concern is that we're looking at the application as an amendment to the previous application that we went through with the mine and not looking at it as its own application, which is what it really is. And not sure that we're following in an effort to do a favor to make an event happen. I'm not sure that we're following the same standards that we would have before.
Got it.
Bill, it looks like you have a question. Are you?
Yeah, and I'm with Gavin on this. And I understand that the city commission really wants to do this. The city manager really wants to do it, and it's an exciting opportunity for the city. But the normal process is the planning and zoning vets these things out in great detail and asks a lot of detailed questions, and then makes a recommendation to the city commission. So they don't have to spend that much time on it. They kind of depend on our expertise and the time we've spent to really vet the thing out well. And we did vet it out well last time, and I think we did a good job. This time, I think we're being told, hey, we don't have any details, but go ahead and pass it on to the city commission. They'll do all the detailed work. And I mean, I don't want to be the party pooper that says I'm not going to pass it forward. I would be willing to say something like planning and zoning was given an information item that we didn't vote on or something like that. But I see a lot of pitfall. You know, we approved it last time, and my initial reaction was say, well, we approved it once, we can approve it again. But now you got the COVID thing that puts a whole different dimension on everything. You've got people that have been pent up for by October 9 months, and they haven't been able to come to large gatherings. This may be the first one, and you come to in cars, and no alcohol is going to be sold, but you can believe that everybody will have a cooler. And if you're not selling alcohol, then you don't have any checks on if you're 21 or not before you buy it. Everybody's going to have a cooler in their truck, and you say people are going to gather around their car when they get here. That's not going to happen. People are going to go and find their friends, and they'll gather in groups, and it'd be very difficult to control.
Well,
So
we do plan on having. Sorry, I apologize.
I got the floor right now, Mr. Bishop, so let me finish my thing, okay? So
My fault. Yeah.
As much as I'm excited about this, and I'd love to see it happen in Newberry, it just scares me that we're rushing something through that has this much opportunity to become a COVID hotspot, to become a place where hundreds of people are driving away under the influence, and youngsters under 21 are heavy drinking because there's no, and you know, and you can say we're going to try to supervise them, but even the police can't supervise people in this day and age. People are rowdy and not often not compliant with law enforcement or authority. So I just have a lot of reservations about it. Not to say I'm going to vote no and stop and try to block it or anything, but just to say that this is going forward at breakneck speed with very little thought going into it. And I'm not going to say that I'm going to vote to approve it for the city commission to approve, or I'm going to recommend approval for the city commission, because I just can't do that. I'm afraid that, I mean, I think the city commission will review it, and the fire department and law enforcement will go over it, but they haven't done that yet. So I don't think we as planning and zoning are in a position to say we're going to put our blessing on this, and that's all.
Okay, other questions from the board members? Brian, you know, this board looked at allowing one special temporary use permit for the mine, used at the mine's discretion. Is this that permit, or is this a separate permit? If the P&Z says, yep, you can do this, the mine, this is yours. Is this it?
No, Mr. Chair, this would be more akin to the city's replacement of the special temporary use permit they were granted for Westfest. This wouldn't affect the STUP that was approved for the mine, because that was just a substantially larger event that they were going to test out as a first run. This is so significantly smaller, and in fact significantly smaller than Westfest was going to be. We would see it more akin to a replacement for Westfest, especially since the city is likely going to be a sponsor of the event.
Well, I have to, this tonight seems to me very reminiscent of the very first time the mine came in front of us, and it kind of switched how we normally do things. And they were asking for us to say we approve without any of the vetting work that this board usually does before they attach their name to it. And I understand the time crunch that we're under. I understand what Sister Hazel has said and what they've been trying to do. And I know that we've been working with them to set this up for a period of time now, and the date has just sort of kind of all coalesced that puts us here. But I hate to ask the P&Z to put their name behind something that they really haven't had a chance to say. And so I guess my question to Rich or Scott I like Mayor Conrad's suggestion of pushing it to the commission, but saying to the commission, we really didn't review that. We can't say yes or no. We heard a presentation from it, but we didn't do any of the normal work. But so we can't give you a recommendation. But we did hear this item, but we've never done anything like that before. So I don't even know what that verbiage would be. Clearly the commission is the board that ends up having the final say. But I agree with Bill that they depend on this board to do a lot of the legwork, to ask a lot of the questions and tweak the proposal. Is there a solution that doesn't ask this board to say that they've done something that they haven't done?
Mr. Mayor, there's 3 or 4 options that the board can consider. Obviously, one would be to grant the application or approve the application. Another would be to approve it with conditions. A third option, which might be more along the lines of what Board Member Conrad is talking about, would be to deny the application, but state the reasons for it. And I think you could go through your reasoning, just reiterating some of the points that have been made, and it would then find its way procedurally in front of the commission regardless, and they would be able to factor in the circumstances that the board was up against as we sit here, on September 8th. So that would be an option. Which I think is probably procedurally as close to what you're talking about.
I agree. And I think that what the applicant needs to understand is what the attorney just said. Whether this board says yay or nay, the applicant still has the right to advance it to the commission to make one final appeal. So this board could say we are denying the application because it's not a complete, we didn't hear a presentation. And their liaison could communicate that to the commission, then you as the applicant would have the right to choose to still go in front of the commission and fill in all the blanks that we can't fill in here tonight. And that would keep, ideologically, that would probably be the most consistent thing for this board to do, to say we don't have enough information in front of us to say yes, but we're saying no because we lack the information being in front of us. And that would give you the opportunity to try one more time in front of the commission. Chair Baker?
Mr. Mayor, one other option that I don't know is if it's feasible or not, and something similar to what we did originally with the special request for the one concert for Theme Mine, is I know that because we heard it over 2 meetings, and they brought us significantly more information on the second. And I believe it was scheduled already for the Board of Adjustment Commission when we had the second meeting. That it was scheduled, and we had the second meeting to determine if we would vote, if we would send a recommendation on. We could do that, but we would have to have a special planning and zoning meeting in advance of which still puts us on a huge time crunch. But if the information is coming as quickly as the applicant suggests, we would have an actual opportunity to look at it prior to the scheduled Board of Adjustment Commission meeting on the 28th. 21st. No, 28th. 28th. I'm looking at the calendar and apparently I can't read. Sorry.
Another option, we could continue just like we did item 3. We could continue this item if this board is willing to come back for an emergency session, not emergency session, but a special meeting of the P&Z, as long as we had it before. That would put the applicant needing to get everything finalized and finished still before the next, before the commission meeting. Is that, Brian, tell us what the timeline of that would look like for the board's consideration.
Mr. Chair, most likely it would be, if we follow the typical pattern of Monday meetings, it'd be Monday the 21st, and which would still give us 1 week to prepare the planning and zoning report for the Board of Adjustment on the 28th. If the applicant thinks they'll have more of the information available earlier, we could schedule it sometime later next week in the Wednesday the 16th, 17th, Thursday the 17th, something like that, if you wanted that little extra time between then and the 28th. So it's certainly doable if the board is willing to come back for an extra special meeting.
Do those timelines give us the appropriate amount of time to publicly advertise?
They do. What we would do is we would go ahead and advertise for the Board of Adjustment hearing on the 28th. As if the zoning board's recommendation had already been completed. And then presumably once enough information is available and the board feels comfortable making their recommendation, then they would make the recommendation. It wouldn't alter the schedule for the Board of Adjustment hearing.
And just to point out, our code requires notice and advertising for the Board of Adjustment for STUPs and not for the planning and zoning meeting. So I would still follow that schedule and submit an ad on the 15th to run the 17th for the 28th Board of Adjustment. And I would do letters to the surrounding properties on the same schedule to be out the 17th.
I have a question for the applicant. For a concert that's on October 23rd, when are you looking to start selling tickets?
We're hoping to get them on in the next week or so. But with this, I mean, we'll have to make an adjustment. I mean, we'll get the Tampa and Orlando ones most likely on sale by the end of the week. And then we'll, figure out what the timeline looks like once we, figure out these next meetings and when the approval would be. They have a live stream, a worldwide live stream on September 25th that they were hoping to be able to really massively advertise, at least digitally, worldwide on, during that stream.
There's no way we this item through P&Z and the commission, which is the ultimate decider, before the 25th.
Okay.
I don't think there's a way. Is there? There's no way to make that. So even if this board were able to say tonight, that wouldn't give you absolute certainty. Well, I guess if this board recommends it tonight, when would the commission hear it again?
28th.
So we still wouldn't hit that 25th mark.
Correct.
That would give you complete certainty and security, sir. So.
Okay, and it's not necessarily a deal breaker for us. I mean, that area, they're from Gainesville. This is one of their larger markets. So let's just see what's going to make sense and, when we can get it approved and be able to get it on sale, as quickly as possible. If that's not till September 29th, then, we'll have to work around that.
Well, and so I know it may not, the last 10 minutes may not have sounded like it, but I absolutely believe we can work these details out and we can figure out how to do this. It's just this time crunch has kind of thrown our procedure, so let's.
I completely understand.
If the board doesn't have any questions, let's move from deliberations to final arguments. And then, or let's move from questions to final arguments. And then in deliberations, we can discuss how do we want to proceed? Do we want to come back for an emergency meeting? Does that make sense? Do we want to simply say no, but make it clear to the commission that we're saying no because we had an incomplete presentation, and so we're not in essence saying no. So let's do that. Any other questions, Brian?
Mr. Mayor, I guess
you're the man who gives us the answers.
I'm sorry.
That you can't ask any questions because you're the man who gives us all the answers.
Well, it's not an answer. It's a suggestion or a request. I guess staff's request would be that rather than denial based on lack of information, it would be approval conditioned upon the provision of adequate information under certain conditions. And so it would, the board would outline, we approve, but only if this, and this are met prior to the Board of Adjustment hearing.
I mean, in essence, that's what we did with the special use permit from the mine. We said, even after the second meeting, we gave them a list of conditions and said, if you get these all done, and staff checks off on them, then you've got it. Is that right?
My concern with that is that, again, since this is technically a separate application, we're in a position of we don't know what we don't know. And so it's difficult to come up with a list of items that they've got to adhere to, and we literally have nothing to look at.
Who is that?
Who's talking? Who was that?
That was Gavin.
No, I heard Gavin, but I heard a female voice after Gavin.
Oh.
Maybe that was somebody in the background. Bill, did you have a question? Your hand go up?
Yeah. So have we decided we're going to have another meeting? So, and if so,
Yeah.
can we come up with that list of conditions at our next meeting when we know a little bit more about it?
I think we haven't decided we're having that next meeting yet. It's on the table. But I think that's a good suggestion. If we have a next meeting, we need to be clear with staff what staff has to come back with in order to warrant us having a meeting. We don't want to come back to another meeting to hear that we still don't have everything, right?
Yeah. And, we had, the last time, I think we had 12 stipulations that they had to fulfill. And we could probably start with that as a boilerplate and then add other concerns about COVID and underage drinking and things.
Okay. Any final questions before we move to final arguments? Okay. Well, so we have an opportunity for the applicant to make a final argument and then the staff to make a final argument. Is there anything you've heard in this that you think you could perhaps sway the board's mind by addressing some of those concerns right now immediately? You don't have to make a final argument. Do so.
As far as the COVID situation, the distancing, and with the Orlando and Tampa shows both, we are planning on having security throughout the area. People would be required, and it's in the ticketing messaging or the language as you're buying tickets, that you are to stay within either in your car or the space next to it, unless you're going to the restroom or that kind of situation. We're not 100% sure. I would like to figure something out as far as like a delivery system, a golf cart delivery system from the concessions, and do some sort of text in ordering or something like that. We don't have that stuff fully fleshed out yet, but I don't think it's unreasonable in working that out. And
but
we
I'd like to hear that from law enforcement that they can enforce that, because that sounds very difficult for law enforcement to keep people near their car and
we would have security guards kind of walking around more than just police officers. So it would be the police officers that would be there, but they wouldn't necessarily be the ones doing the enforcing. And it's spelled out, and I'll send you guys the language that we have the ticketing or for the ticketing site. We're just finalizing that stuff today, though.
Okay. All right. Thank you, sir. Staff, do you want to make a final argument? Okay. So we've heard a lot tonight, and we've thrown around a couple of ideas. It seems like it may be the prime idea to set another date for us to come together to hear this, so that we're not denying it. Can I just have a head nod? Is that what we kind of want to work towards, another meeting? And we're all willing to do that extra meeting. So Brian, remind us again, and I'd ask the applicant to really, if you've got a calendar, open it up here and let's look at it and see exactly how much time we can give you while still getting it in before it goes in front of the commission. When's the last date for us, Brian?
Well, I mean, as Janine said, we'll be putting in the ad next Tuesday to run on the 17th. The mailed notifications go out at the same time. So really, it's anytime before, say, Wednesday the 23rd. If we had that would just give us one day to put together the Planning and Zoning Board recommendation report for the Board of Adjustment. But we could go as long as that. I would recommend, that we meet again prior to that, hopefully no later than Monday the 21st.
You're talking about September 23rd?
Yes.
September 23rd. Sir, would that give you enough time? And staff, we're going to reach out and work with the applicant on what kind of information they need to bring and what kind of questions these guys, would that 2 weeks give you enough time to answer some of these? I've heard you say that you're going to have some of this information within 24 to 48 hours, that kind of stuff. If we got you on the
Yeah, no, if I've got a list, but yeah, that 2 weeks should be plenty of time, I think, to get whatever we need to you guys.
The 23rd, and this board approves, then I think you could probably feel fairly certain about advertising it on the 25th, because the commission has a lot of respect for this P&Z board and their opinion. Does the 23rd sound good to everyone else?
It would be advertised before the 25th.
I'm talking about their advertising during their concert.
Oh, okay.
Okay, so we're all agreeing to come back on the 23rd.
Well,
so,
just
Mr. Attorney, does the applicant need to ask for a continuation, or can I ask for the continuation time certain? What's the procedural correct way to?
Two options: either the applicant can ask for it and the applicant gets it, or a board member can make a motion and second it and then vote on.
I would prefer if you ask for it, sir, because then if we had to make a motion, we got to go to public comment. It's a whole thing.
Yeah, can I ask for a continuance then?
Absolutely. We'll continue it on September 23rd. Brian?
Mr. Chair, I just want to make sure the board remembers that's a Wednesday, and I don't know if there's church considerations that would cause us to potentially not have a quorum on a Wednesday evening.
So we've got 4 here. Do I have a head nods that we could tune in at 6 o'clock from at least 3?
Yes.
Okay. I saw 4 head nods. Awesome. All right. Then this item is continued. Thank you, sir, for your time. Again, apologize we weren't able to bring it to resolution tonight, but I look forward to working with you to make sure we have a successful outcome on the 23rd.
Sounds good. Thank you very much for your time.
Thank you, sir. Okay. That will pull us out of quasi-judicial. Bill?
Before we leave this subject, I'd like to ask that we have a representative from the Sheriff's Department here on the 23rd, because that's what sold me on it the last time. When the Sheriff's Department came here and said, we got this, we got the traffic under control, that made me comfortable with it. I'd like to hear the same thing from law enforcement about this concert.
Okay, staff, if you can make sure that this applicant does the same great job that the last applicant did when we were helping, address some of those concerns that we can see coming and sometimes the applicant can't. Okay, now that will pull us out of the quasi-judicial and on to item 5 on tonight's agenda, which is discussion on future planning and zoning board meetings. Are you guys comfortable continue to Zooming? Do you want to try to do a live Zoom hybrid? The commission has gone to a live Zoom hybrid. It does give the opportunity for people to come and address you face to face, but it also provides you and staff the opportunity to make a decision about whether you want to be here live or whether you want to Zoom. Thoughts?
I will say that as much as I don't love getting on Zoom meetings all day, I do it a lot for work, and I think that we've been really effective at coming together this way, and our meetings have matured a lot. We've been able to get things approved. So I definitely support having the option for members to Zoom in.
And whether you guys want to go live or not, we will still do the Zoom option. So if you want, it'd be a Zoom live. And I guess after having experienced many Zoom live hybrids, while there are some advantages to being able to come live, if you're going to Zoom, you might as well just Zoom and have everybody Zoom in, because the live hybrid Zoom creates some issues for backfeed and sound and all that kind of stuff. Janine, it looks like, are you trying to?
I would like to point out that, we're having this discussion, great, but right now, so it's contingent upon the governor's order continuing. And right now, the governor's order expires at 12:01 a.m. October 1st.
Well, if the
So,
government
like,
takes the order, then there's no conversation though, right? And then we're just back to live.
Correct. If he quits the order, we're back to sunshine law live.
Yeah.
Yeah. And one of my concerns about the hybrid is the staffing level required, and that there is not, Brian, correct me if I'm wrong, there's not a budget for the planning and zoning meetings, like there's a budget for the city commission meetings. Because we would have to have, my thinking is 4 support staff there, could get away with 3 maybe if nobody used the restroom. But in order to follow the guidance and have City Hall open, we have to have somebody taking temperatures who's an EMS. We have to have somebody running the AV. We have to have somebody monitoring that there's only 17 in the room. And if citizens want to come in and out, they got to know which citizen's speaking on which issue, that kind of thing. And then the restrooms have to be cleaned after every use. You know, facilities has to clean the room before and after the meeting, but after every individual use, the restroom has to be cleaned.
Okay. Bill, were you trying to get in?
Yeah, you know, I don't care if you have the live meeting or not. I'm going to Zoom because I'm in the high risk category. I think I speak for member Woodcock as well. We're not going to be around groups of people, no matter what the governor proclaims. Well, I guess if he says we can't do it on Zoom, we're in a quandary. But I've got all the risk factors, and I can't be in a room like that.
Okay.
I also think that one of the considerations we have to have, depending on what happens with the executive order, is that with HARB up there, we have, with the 2 extra members of HARB, we're really squished in on the dais. And so even if we go back to fully live, we should think of how we can configure ourselves to be a little bit more spread out.
It doesn't sound to me like anybody is really interested in doing a live hybrid model. So I would direct staff to begin making plans and preparations in case the governor doesn't extend the order, and to think about how we're going to address some of these concerns, especially for our elder staffers and our elder board members, right?
Yeah.
We may need to look into the law about what happens if we have board members who say, does that mean that they have to resign because we have to do live meetings? Hopefully the governor's order would at least allow you to continue doing some sort of hybrid versions to address that concern. But I think we can probably, since it's getting so late, we can leave it here tonight with staff is going to keep a close eye on this issue towards those considerations and concerns and have answers for us. Janine?
I do want to say there's only one additional member right now on HARB, and that's Peggy Loy. And she did email me that her preference, if the health situation was resolved, would be to go back to live meetings.
I think that's everyone's preference. If the
So
health
just so you know.
He
He emailed me, I want to report it.
Yeah. Okay. Any last thoughts on that? Everybody good with leaving that conversation there? Okay, topic for member discussion, Chair Baker.
Nothing.
Naeem?
Nothing.
Gavin?
I just want to say thank you to Chair Baker for on our first issue that came up tonight. She said no, which wasn't the common vote, and I appreciate us having, that's what we're here for. If we say yes to everything, it kind of defeats the purpose. So.
Hear, hear. Bill?
Nope.
Okay. Do we have any closing comments from staff? I have nothing on my agenda about citizen comment, which it's getting late, so maybe I'm forgetting that. Do we normally do citizen comment at the end of the P&Z meeting? It's a public meeting. Brian, do we have anybody in the waiting room?
No, Mr. Chair, we do not.
Okay, well, it's not on the agenda. We don't have anybody in the waiting room, so this meeting is adjourned. Rich, don't leave the meeting yet.